Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group with offices in New York, New Jersey, and we also have affiliated offices in Canada and in India. And with me again today is Ravindra Singh, one of the attorneys here in our office, and Ravi and I work very closely on H-1B matters as well as other employment-based matters and family-based matters. And we're pleased to be able to bring to our viewers some additional information that might be helpful for you as we are winding into H-1B season, and we're starting to get H-1Bs ready for filing.
Sure.
So, Ravi, what are some of the questions that some of our viewers have that we want to probably address?
Basically, if we could talk about the salary issue first again, and then we will go into the compliance issues, some of the compliance issues like the posting of LCAs or how to maintain a public access file.
Okay, so let's talk about the wage, because I think the wage is a really important issue. What ends up happening is that a lot of employers, once they find out what the federally mandated prevailing wage is for a particular position, they often are deterred from doing an H-1B because they look at the numbers that are being promulgated by the U.S. Department of Labor and they say, whoa, this doesn't really apply to that job. So, oftentimes there's a disconnect between the numbers that are being reported by the Department of Labor and the reality of what a business provides. And in fact, it's even, this is additionally shown in the public access file, which you referred to before. In the public access file, you have a subjective and an objective wage methodology. So these are two different things. So there is a bit of a disconnect between what the government is reporting as the wage and what oftentimes an employer will pay. But what's the issue on the wages for the H?
The first thing about salary is the employer should pay the higher of the actual wage or the prevailing wage in the area of intended employment. So the employer, and that determination should be based on the best information available to the employer.
Exactly. So, and that information comes by way of going to a portal that you have access to. It's www.doleta.gov, right? So that's one portal. But the other thing that an employer can do is they can get a wage survey, so they can do a private wage survey. And what if it's a unionized? Employer?
Yes, if it's a union position, again, we normally call it collective bargaining union, or you have a collective bargaining representative in your area, then that union determines the amount of salary your employer will be paying. If there is no collective bargaining representative or a union in that area of employment, then the employer could submit either a private survey or they could submit an OES wage survey that could be obtained by going to flcdatacenter.com. So the employer has different options, but the bottom line is the employer should be paying the higher of the actual wage or the prevailing wage in that area. So David, you want to talk about how an employer should determine the prevailing wage?
Actually, yeah, and what I think it's really important to realize, because this is an employer's obligation under the H-1B, and that's a question that we always get, is that oftentimes people will reach out for us. It's not the employer, it might be the individual. And so their first question is, well, my employer wants to know what their obligation is for the H-1B. So obviously the first obligation we always mention is, number one, they have to, the employer has to pay the Department of Labor training fee. As we pointed out in our earlier video, that Department of Labor training fee depends upon the number of employees that you have at the place of business. So for example, if it's 25 full-time employees, it's going to be, if it's under 25, it's $750. If it's over 25, it's $1,500. That the employer has to pay. The employer does not have to pay any other fees associated with the H-1B. However, it's very important, because the Department of Labor has said this, that if it seems like that the wage is going to be driven below the federally mandated prevailing wage by virtue of the individual paying these additional fees associated with the H-1B, then that's going to be problematic. So you need to look at that particular issue. where this whole, and then, so that's the first obligation. The next thing an employer has to do is fill out what's called an LCA, a labor condition application.
That's right.
Not to be confused with the labor condition, the PERM process, the labor certification process. So I always get this question from individuals who say, well, I have to show that there are no U.S. workers who can take the job because we're doing a labor certification, right? But that's not what the LCA is about. The LCA, the ETA 9035 form, is about attestations that you're not displacing U.S. workers, not about that there are U.S. workers who can potentially take the job.
I also want to bring to attention is that there is a confusion when you say an exempt employee and a non-exempt employee. So the additional attestations are required only when you are hiring a non-exempt employee. So first thing I wanted to bring to your attention is when we talk about exempt and non-exempt employees, and when we talk about the additional obligations of an employer about the displacement inquiry, then you need to understand that whether the employee is being classified, okay, as an exempt employee or a non-exempt employee. If the employer is hiring somebody on an H-1B visa and paying that employee annually $60,000 or more than $60,000, then that employee will be classified as an exempt employee, and the employer will, do not need to make additional attestations on the LCA about somebody being displaced earlier and for the position that is being offered to the H-1B employee.
So the issue that Ravi is discussing has to do with whether or not employees can be exempt for the purposes of a calculation of H-1B dependency. And if you have an employer who, let's say, for example, has a certain number of H-1Bs, but those H-1Bs are being paid beyond a certain wage level, they will not be considered toward the calculation of H-1B.
So it's important to understand, okay, when I say H-1B dependent employer, you need to understand who may be classified, okay, as an H-1B dependent employer and who not. First thing is it depends on the total number of employees you have. And when I say total number of employees, okay, I mean total number of full-time equivalent employees. So basically there is a lot of calculation involved. But the simple thing is, if you have 25 employees and you are employing 8 employees on an H-1B visa, then you will be classified, okay, as an H-1B dependent employer. The second part of this is if you employ more than 25 up to till 50 employees and 13 of those employees are on H-1B visa, then you'll be classified, okay, as an H-1B dependent employer. Again, there's a third prong, and that is if you employ more than 50 employees here in the US and 15% or more of your employees are on an H-1B visa, then you'll be classified, okay, as an H-1B dependent employer. And it's very important to understand why it is important to determine whether you are an H-1B dependent employer or you were classified during the last 5 years, okay, as a willful violator.
Exactly, and this is obviously a technical calculation, but it's one that employers really need to take account of, especially if they're on the cusp. And it's one of the things that we do as lawyers is we'll take a look at whether or not we might be able to shift an employer away from being H-1B dependent by, let's say, for example, taking an individual to a green card. You can take them out of being H-1B, and then of course that would take the employer out of dependency. But I think one of the most important things is that in the event that an employer is H-1B dependent, there are 2 additional obligations that they have to fulfill. One is a displacement obligation, so they have to make an attestation with regard to non-displacement of U.S. workers by the individuals who are serving as H-1Bs. And 2 is that there's something called a recruitment attestation. And the recruitment attestation requires the employer to demonstrate that they've made a good faith effort to try to find U.S. workers for the position. And of course, we work with our employer clients to explain to them what needs to be done to meet those obligations. With that, I think we're running out of time, but what I'd like to do is thank our viewers very much for being with us today. We covered a lot of ground. We will be back, and we will do another H-1B series on H-1B issues. Thanks so much for being with us today.
Thank you.
Thanks.